Thank you so much for coming here tonight and for your interest in hearing about how we can build a better, fairer Australia. It comes as no secret that I'm passionate about human rights, having worked and thought a lot about human rights on my time on this planet. So I'm really looking forward to speaking with you tonight about why we need a Charter of Rights in Australia and why it's so important for Australia and how it can build a better society here, one that's grounded in the values that we all care about, like freedom, equality, respect, compassion, and dignity. It's an honour to be asked to deliver this lecture and to follow in the footsteps of people who I greatly admire, like Cathy Branson, Marcia Neve, Gillian Triggs, and Michael Kirby. I also want to recognise Rob Hulls, who's here tonight, the Director of the Centre of Innovative Justice here at RMIT, and his team. Rob has been an absolute champion through his career for human rights and social justice, particularly so as a progressive Attorney General who left behind a proud legacy of reform here in Victoria. We don't yet have an Australian Charter of Rights, but we do have a Victorian Charter of Rights, and it's largely thanks to Rob's championing that cause that happened. I also want to acknowledge the RMIT law students who worked on a recent project outlining the difference that an Australian Charter of Rights would make, and I'll be drawing on some of their work tonight. In talking about a charter tonight, I want to talk about human rights in our past, in our present, and in our future. And it's appropriate, given this lecture is named after George Higinbotham, to start there in the past. I'll confess that I didn't know much about George Higinbotham before I was invited to deliver this lecture, and I want to thank Geraldine Moore, who's here tonight, who is writing a book about George Higinbotham, who reached out to me at a very timely moment. So Higinbotham, as Anthony said, an early Victorian Chief Justice, but also much, much more than that, a journalist, a barrister, a reformer, a free thinker, and a politician. He arrived in Victoria 19 years after John Batman sailed up the Yarra River and presumed to start a new settlement on the lands of the Kulin Nation, sparking the next round of dispossession of Aboriginal and Torres Strait Islander people. There are many in our society today who seek to downplay the impact of that devastation, the devastation wreaked by Europeans and their settlement on our First Nations people. A devastation that has rippled across generations and still reverberates today. So it's appropriate in acknowledging that tonight, as we're meeting on the lands of the Kulin Nations, to quote from one of the editorials from Higinbotham's paper in 1859, when he was editor of the Argus, and we assume it was Higinbotham who was in fact writing this. And he wrote, "The treatment of the Aboriginal people has, from the very commencement of the settlement of this continent, been a standing reproach against the colonists. Dark stories are told in bush circles of murder by wholesale and in detail, by open force and by cunning plot, by which it was sought to exterminate a troublesome race. The circumstances under which we took possession of this land were more those of a hostile invasion than any other, and it is from this people who we have expelled from their own territory that we have seized the vast area of rich lands on which we're settling a new nation. Whatever right of title we may claim on the ground of discovery, the great fact can never be ignored that these people were first in possession, that Australia is their native land, and their right to obtain from its soil the necessities and comforts of life is an inalienable one." What a contrast to today's debates about acknowledging past atrocities. Higinbotham, like many writers of his time and later, goes on in his editorial to contemplate the complete end of the Aboriginal race. And it's of course a tribute to the resilience of Aboriginal and Torres Strait Islander people that they have survived, that they have endured. Their culture continues in spite of the dispossession, in spite of the injustice, and in spite of the ongoing racism. And I want to acknowledge the many Aboriginal and Torres Strait Islander leaders who have done so much for human rights for their people and for this country. An Australian Human Rights Charter will benefit all Australians, but it will particularly benefit those who are disadvantaged. So it holds particular promise for Aboriginal and Torres Strait Islander people. I was born close to a century after Higinbotham died, and I now live within walking distance of his grave. I was lucky in the lottery of life on this planet, being born into a stable, safe and prosperous country, into a loving, safe, happy and financially comfortable family. I studied arts and law at Melbourne University and then started my career, as Anthony said, at one of the top corporate law firms. It was a good introduction to one aspect of our legal system, but it's never where I wanted my career to lead long term. So after a few years, I took up the opportunity to do a secondment to a community legal centre under a scheme set up by then Attorney General Rob Hulls. I went for a nice office on level 30 of the Rialto in Collins Street to a demountable site shed in outer suburban Melbourne. When it rained on the tin roof, you couldn't hear the clients on the end of the phone. And when the sheep trucks went past on Ballarat Road, the whole office physically shook and you could smell the animals outside. Those first 6 months at the Brimbank Community Legal Centre are where I properly started to understand human rights. We worked with people on the fringes, people facing family violence, grappling with the consequences of sexual assault, or facing mental illness. We helped prisoners, victims of crime, refugees, people in poverty, people in ill health, people struggling with deep disadvantage. It was over a decade ago now, but I still remember very clearly the people we worked with. A young woman recounting childhood sexual assault by her stepfather, a mother crying as she heard her young son tell me in their home how he, when he was in prison, had been bashed brutally by prison guards, how he couldn't trust anyone anymore, and how he'd become a hardened criminal. Another mother who had completely turned around her life for herself and for her beautiful 2 children, who was then summarily sacked from her job after a criminal record check revealed very old past prostitution and drug offences. The contrast from corporate law could not have been starker. In a corporate firm, Australia's biggest companies could access the best lawyers and all the access to justice that their money could buy. At the Community Legal Centre, the need for assistance was huge and justice was remote and hard to reach. Every day we made tough decisions about who to help and how much to help them, knowing that every hour we spent with one client was an hour that we couldn't spend with the next client who needed legal help. I ended up managing that centre for the next 3 years, and through my time there, I convincingly saw how the law can empower, how the law can uphold dignity, but also how the law can entrench disadvantage. The injustice faced by our clients deeply motivated me in my work and continues to motivate me. But instead of addressing injustice through individual client work, case by case, sometimes in band-aid solutions, my work over my career has become focused on fixing the system, fixing the laws and policies that generate and allow injustice to occur. And that's why I'm so passionate about an Australian Human Rights Charter. To understand how a charter will work and how it will benefit Australia, we need to first understand human rights. Human rights are the rules that governments around the world have promised to comply with, rules that ensure that every single person, no matter who you are or where you are, can lead a decent, dignified life. They're rules like the right to be heard, to be safe, to vote, to stand for elections, to have food, a reasonable standard of health, education, and more. They're grounded in shared values like freedom, compassion, decency, respect, and equality. When we drive or take the train to see friends and family, we enjoy our freedom of movement. When we join a trade union or a community group, we enjoy our freedom of association. When we attend a protest, we enjoy our freedom of assembly and our freedom of expression. When we attend church, a mosque or synagogue, we enjoy our freedom of religion. When we take our children to the doctor, we enjoy our freedom of our right to health. And when we access jobs, goods and services, regardless of our gender, age, religion or race, we enjoy rights to equality and to non-discrimination. Under international law, most human rights can be limited or restricted, but only if that limitation is reasonable and if it's necessary to achieve a legitimate goal. So, for example, freedom of expression is not an absolute right, and it can be limited justifiably to stop threats to kill, to prevent child pornography, or to stop racist hate speech. Human rights have got a long history going back to the Magna Carta and earlier. to the rule that no one is above the law, not even the king, to the rule that you can't be locked up unfairly or punished without a proper trial. Modern human rights stem from the Universal Declaration of Human Rights, adopted 70 years ago this year. After the horrors of World War II, the international community came together and said never again. Out of the nadir of mass slaughter and human suffering, they drafted a document that should rightly be celebrated as a pinnacle of human achievement. Australia was closely involved in the push for the Universal Declaration, and Australian William Hodgson was one of just 9 drafters of the Declaration, led by the extraordinary Eleanor Roosevelt. Our Foreign Minister, Doc Evatt, was strongly supportive. On the 10th of December 1948, what's now International Human Rights Day, Anthony, fun fact, also my daughter's birthday, the Declaration was adopted by the UN General Assembly. Its first article declares that all human beings are born free and equal in dignity and rights. In doing so, it says to every single one of us, no matter who you are or where you are, that you have value, that you matter, that you deserve dignity. In coming after slavery, genocide, eugenics, and more, this universalism was critical. It's a concept that seems unremarkable now, but it wasn't then. And the fact that it's unremarkable now speaks to one of the great successes of the human rights movement. The Declaration then goes on to list 30 articles or rules that protect human rights, from the right to life to health, housing, and social security. All rules which governments must respect in dealing with us because of the mere fact that we are human. The Declaration sparked the major international human rights treaties that successive Labor and Liberal governments would sign and ratify in coming decades, with the Turnbull government most recently ratifying the protocol to the Anti-Torture Treaty on Human Rights Day last year. And all of this international law sounds excellent, and it is. The problem, though, is that in Australia, when our government commits to an international treaty, unlike some countries, that treaty, those rules, those obligations don't become part of our domestic law automatically. So if the Australian government locks you up unfairly, you can't take legal action in Australian courts saying that the government has breached Article 9 of the International Covenant on Civil and Political Rights. Instead, under international law, Australia is meant to ensure that its domestic laws comply with the obligations that it has promised to uphold at international law. And this is where the problem lies. Instead of comprehensively protecting human rights in our domestic laws, instead we have an incomplete patchwork of protections through legislation, the common law, and the very few rights that are in Australia's constitution. Free speech and association are only partially protected. The right to privacy is only partially protected. The right not to be locked up unfairly, and so on. At the state and territory level, only Victoria and the Australian Capital Territory have human rights charters that apply to those governments respectively. Unlike every other Western democratic nation, we do not have a Charter of Rights that protects our rights in law. We have less rights protections than our friends in New Zealand, Canada, the UK, Europe, and so on. Does this matter? Of course it does. We live in one of the safest, most stable and prosperous countries on the planet, and we should celebrate the fact that Australia is one of the most successful democracies. But that safety, that stability and prosperity has not been shared equally. Governments and people in power have abused rights over our history. The shameful treatment of Aboriginal and Torres Strait Islander people, to the criminalisation of homosexuality, entrenched sex discrimination, the White Australia policy, and more. Our past is littered with human rights failures. On the White Australia policy, with its notorious English dictation test, my own family history highlights how incoherent and prejudicial and unjust that policy is, and how fortunate I am to have grown up here. My father's family are Dutch Burgher Sri Lankans. They're descendants of Portuguese and Dutch settlers in Sri Lanka who over centuries became of mixed European and Sri Lankan descent. The only reason my dad's family was able to emigrate to Australia in 1949 under the White Australia policy was because, absurdly, they were able to prove their European heritage by tracing our line back to a sailor called Hugh de Kretser, who sailed from the port of Texel in something like 1649. But the arrival of European Sri Lankans with non-European appearances caused consternation. And in 1951, the Department of Immigration sent a cable to the Australian High Commission in Colombo that said that it should not authorise the entry of persons who are likely to cause adverse comment on arrival or be restricted from landing by immigration officers at the ports as being predominantly non-European in appearance. So in many ways we were lucky. But fast forward to today, and we have politicians advocating for a return of racially selective migration policies, for a ban on Muslim immigration, for prioritising immigration of white South African farmers and denying immigration, stopping it from other African nations, for an English exam to qualify for citizenship set at a standard that many Australians would fail. Today, most of us enjoy our human rights without thinking much about them. We just assume them. And that's partly a good thing. It partly reflects our success as a nation, but it's also a recipe for complacency, because it's clear that for many people in Australia, and many people who Australia affects, human rights cannot be taken for granted. They are sometimes part of a daily struggle for dignity, for respect and for equality. It's clear that for many, human rights matter deeply. If you're living with a violent partner, human rights matter. If you're being bullied at high school for being gay, lesbian or trans, human rights matter. If you have the onset of dementia and face the prospect of someone being appointed to make decisions for you about your money, your medical treatment, where you live or who you spend time with, human rights matter. If you're a migrant being racially abused on public transport, the sporting field or at work, human rights matter. If you're one of the thousands of young people with disabilities forced to live in old age nursing homes, human rights matter. If you're living in a remote Aboriginal community with grossly inadequate housing, seeing your friends and your family dying too early, and your community hit by punitive laws that see too many Aboriginal people locked up and sometimes dying in our jails, human rights matter. And if you're a refugee held indefinitely on Manus Island or Nauru, despairing for your future and fearing for your safety after 5 long years, human rights matter. Sadly, there are far too many examples where our current system of protecting rights is failing us. We see it in our work every day at the Human Rights Law Centre. Right now, we have refugee clients here in Australia who can't buy food or pay for housing because they have no access whatsoever to social security. We have families split across Australia and Nauru and Manus Island merely because of an accident of fate, because they arrived on different boats either side of a policy change by government. So a father held by a government on Manus has to watch each year for 5 long years now as his son, living and going to school in the Australian community, holds up a Father's Day card to a dodgy Skype connection. A wife held by a government on Nauru has to endure the pain of separation from her husband in Australia, speaking daily on scratchy and often disconnecting phone calls, not knowing when, if ever, she'll be able to hold him again. And a father forced apart from his wife by our government when they stopped him travelling with her to Australia to give birth. He can't be with his first baby boy, born in an Australian hospital, living in the Australian community. He can't be there as his son takes his first steps and speaks his first words. Our government is depriving a child of its father and a wife of her husband. Our politicians have been too willing to trample on rights to protect their power. Our public servants have been too willing to enable those policies, and our parliaments have been too acquiescent in approving laws that undermine rights. And we're in the midst of a trend, both here and abroad, where populist authoritarian leaders are explicitly trashing hard-won human rights guarantees to protect their own power. At the federal level, many of these rights problems arise in the immigration and national security context, but the issues are far, far broader than that. The Australian Law Reform Commission was tasked with the job of identifying federal laws that potentially breach rights. Despite being specifically prevented in their terms of reference from looking at laws that allowed people to be locked up indefinitely and unfairly, or laws that breach privacy, they still identified over 100 federal laws that potentially breach rights, from secrecy laws to laws that reverse the presumption of innocence. An Australian Charter of Rights would better protect all of our human rights. It would fill the holes in our patchwork protection of human rights in this country, creating a better rights safety net for all of us. It would help to ensure that government complies with the rules that it has promised to comply with under international law. It would build a culture of rights, of respecting the values we care about. There are different models that a charter could take. The strongest protection of human rights would come from enshrining a Charter of Rights in our Constitution, the rule book for our nation. This is the version adopted by Canada, South Africa, and the US, although their Bill of Rights is conceptually quite different. Constitutionally protected human rights would override any laws passed by federal or state parliaments that breach rights. A constitutional charter, however, would require a successful referendum for implementation. A more achievable option is for a legislative Charter of Rights. This was the model proposed in 2009 in the human rights consultation led by Father Frank Brennan. That consultation received over 35,000 submissions, hosted 66 roundtables in 52 locations throughout metropolitan, regional and rural Australia. Over 80% of submissions and a large majority of people polled in social research supported a Charter of Rights. Yet the Rudd government, in its spiralling final months, failed to act on this support and this recommendation. A legislative charter would be a normal piece of legislation passed by the Australian Parliament, which the Parliament could change if and when it wanted. And this is the version adopted here in Victoria, in the ACT, and overseas in the United Kingdom and New Zealand. A legislative charter would provide an enhanced rights-protecting role for each of the Parliament, the courts, and for government. A charter would do two key things. Firstly, it would require Australian government bodies, like government departments, the Federal Police, Centrelink, Medicare, and more, to properly consider and act compatibly with human rights when developing laws and policies. It would force them to think about human rights before they act. And secondly, it would give power to people to take action if government bodies cross the line and breach our human rights. It wouldn't give the courts the power to strike down legislation, but they would interpret our laws consistently with human rights and could issue a declaration about any laws that couldn't be interpreted consistently with human rights. And that declaration would then go back to the Parliament to decide what action to take in response. The experience from Victoria and the ACT and overseas is that the biggest impact a charter has had is in developing better laws, policies and services. And most of this work is done very quietly and as part of the normal business of government. Asking questions like, what's the goal we're seeking to achieve with this law? Will it restrict rights? How will it impact on rights? If so, is it justified? And are there any less restrictive ways to achieve that goal? This is human rights delivering good, human-focused law and policy making. But it's critical that there be an effective, accessible enforcement mechanism. That means giving people the power to take action in court if government crosses the line. That power is needed to make sure that governments take human rights seriously, because rights without remedies aren't rights at all. Opponents of a human rights charter argue that they transfer power from elected parliamentarians to unelected judges, setting up a false binary as if only one of those should protect rights, when the Brennan inquiry showed convincingly that Australians want enhanced rights protection from both the Parliament and the courts. In fact, what charters do is they transfer power to ordinary people to protect their rights, by requiring governments to act compatibly with rights, by enabling people to advocate for their rights, and failing government action in response to that advocacy, enabling them to take action in courts to protect their rights. And if your family's being held on Nauru by the Australian government, and your 2-year-old daughter is gravely sick and at risk of dying, when the government's ignoring the advice of its own medical service, when it's ignoring the advice of multiple doctors about the risk to your daughter's life and the need to urgently evacuate her to an Australian hospital, well, that's exactly when you want an unelected judge with the power to protect your rights. Of course, a charter on its own is not enough. We need rights to be well understood in Australia by our politicians, by our public servants, and by the public. We need our community to stand up for rights when they're at risk, the rights of everyone. A charter would be just one of the pillars of rights protection alongside other pillars, like a properly functioning judicial system, a free press, free and fair elections, and more. But the foundations of our nation are weaker without that pillar, the pillar of a charter. So how likely are we to get a charter? Momentum is building. We've got charters in the ACT in Victoria which have been successful based on somewhat modest models. Rob, you needed to do better. Queensland is on the verge of getting its own charter, a legacy of Campbell Newman's success as Premier when he was in government. We need to build on this momentum with a renewed push for a federal charter, which is why we'll be launching a community campaign for a charter and asking you to speak up, sign up, and support the charter. From my career in the law and in human rights, I believe firmly that a human rights charter is one of the key missing pieces of our nationhood. For at its heart, human rights are about the relationships and the communities that we want. As human beings, our destinies are linked, and a threat to the rights of some is a threat to the rights of all of us. When governments treat all of us with decency and respect, with compassion and with justice, when all of our rights are understood, protected and upheld, our communities are better, our communities are fairer, and our communities are stronger. A Charter of Rights will be a big step forward towards a more confident, forward-looking nation, a step towards our common humanity, and a step which we need to take now. Thank you.
Well, thank you very much, Hugh, for putting the case for a federal human rights charter so compellingly and so succinctly. We do have some time now for questions from the floor. We have a number of roving microphones, so if you just want to put your hand up if you're interested in asking a question. And when you do ask a question, if you could please state your name and avoid the temptation to give your own lecture when you're asking a question. While we wait for some hands to go up, I might ask a question and then we'll come to the gentleman in the middle there. So Hugh, you say that the momentum is building for a federal charter of human rights. So where is the debate up to now? And for example, has the federal Labor opposition given a commitment to introduce one?
So we had our best chance in recent history for a charter in 2009 when we had the Brennan inquiry, the Father Frank Brennan inquiry that did that huge national consultation. Brennan was an avowed fence sitter on whether or not we needed a Charter of Rights. In fact, that committee's #1 recommendation was stronger human rights protection in Australia, and it's important to remember that, but one of its important recommendations was a federal Charter of Rights. And incredibly disappointingly, the Rudd government didn't follow through on that recommendation and community support. So we're working now to start to rebuild that momentum. The Queensland Premier, Anastasia Palaszczuk, has made a commitment to introduce a charter based on the Victorian model, and we expect that that will be introduced later this year. We've got the charters in ACT and in Victoria. There's been attempts around Australia, which we're hoping to reignite, to get charters in every state and territory jurisdiction, and we've started talking to federal Labor as well and all politicians federally about the need for a federal charter, and we'll be pushing very hard for that over the next 3 years.
Okay, so we do have a question in the middle there. Thank you.
Simon Smith from the Suzanne and Karen Centre. I think you partly answered my question, which is coming up to a federal election, does the Labor Party have in its platform that they will be doing a charter?
Yep, so the question from Simon was what's the Labor Party's position in its national platform around a charter, and it's how would I describe it? Cautiously supportive of a charter. So they say they'll review the human rights protections in Australia with a view to assessing whether or not we need a statutory charter or similar instruments. So there is a support for a charter there. It's support that we are seeking to get firmed up. The Greens are supportive of a charter. They're on the record. There's independents like Andrew Wilkie who have moved private members' bills for a charter. The best prospect over the next 3 years is a shortened government introducing a charter. The Liberal Party at the moment has no desire to introduce a charter.
Hello, my name is Catherine Phelps. Right now, Article 25 is particularly relevant. Article 25 of the Universal Declaration of Human Rights has to do with housing, clothing, food, health services. And there's a lot of people here, especially in Victoria, who are very concerned about housing because the Labor government has actually been closing down and taking away housing from a lot of people. Now, I think the federal election, surely we could put pressure as the public on not just Labor and Liberal, but all the political parties in order to make it an election issue for the coming elections. And I really think it would be very possible to get a grassroots movement with this. I mean, I'm going to be out at Fed Square tomorrow, where we've got several youth groups all coming out to read every single article of the Declaration at 3 p.m. And then we have a song that's being launched at the Fed Square screen, their big screen. Yep. And I think we could do an awful lot to get all of the politicians concerned and thinking maybe we should make this an issue. I don't know if you think that can be done or how you would do that.
Yeah. When you ask people about which rights they support, the rights that you can't pick and choose rights. Like it's universal human rights for all of us. It's not just for the chosen few. But when you ask people about which rights get the most support, it's the economic and social rights, rights to food, housing and education. They are the rights that politicians are the most reluctant to put enforceable legal protections for. South Africa's done it, and there have been good cases in South Africa where governments have been held to account for their commitments to protect the right to housing and the right to health. In Victoria, the Victorian Charter doesn't explicitly protect the right to housing, but it does protect the right to families and to privacy, and that has been used very effectively, particularly by Justice Connect's homeless law services, to protect, to stop people from being evicted into homelessness. It's one of the areas where the Charter has had the biggest impact here in Victoria. So good on you for your advocacy in support of housing, and we would like to see a federal charter that explicitly protects the right to housing in addition to health, education, food, etc.
I think we have a question at the back.
Yeah. Good evening. I have a question that while discussing about, while giving a speech, you have talked about the South Africa, Canada and US and how in their constitution the human rights has been enshrined. But in all these countries, the human rights can only be implemented if you have a very strong judiciary, an independent judiciary with a power of judicial review. That you have in US, you have in South Africa and to some extent in Canada also. But the Australia followed doctrine of inconsistent interpretation. While advocating this Charter of Rights, are you also advocating this fact that the fundamental jurisprudence of judiciary changes in Australia, like having a judicial review? Because in my belief, that without having a strong judicial review, you can't have a very strong Charter of Human Rights. As you very rightly said that we need unelected judges also sometimes. So do you think this unelected judges thing, that judicial review should also be incorporated in the Australian Constitution?
Yep. So just to summarise the question, just because we're recording this, the question is looking at the enforceability of rights through an independent court system and recognising that there are different standards across different countries and whether or not you should have judicial review. That is the ability to take to court a case that says this action or this decision by a government is unlawful and must be stopped because it breaches human rights. And I've got a few things to say about that. One of the false arguments that opponents of human rights charters put up is they'll say, look at the USSR, they had a great Charter of Rights written in their constitution that was completely unenforceable because you couldn't bring a case in an independent judiciary that would actually protect people's rights. And so that's why you need to combine the rights protection in law with actually the independent judiciary that can actually enforce those rights protections. There is excellent rights protection in the Nauruan Constitution and in the PNG Constitution. And one of the ironies of Australia sending refugees over to PNG is that it was court action under the PNG Constitution relying on its human rights guarantees that actually broke open the gates of the centre on Manus. Obviously people are still being held on that island, but they have some measure of liberty. Yes, of course we need judicial review where judges are able to say, hold governments to account and say you have a legal obligation to properly consider human rights, you have a legal obligation to act compatibly with human rights, and we will enforce that. And the Human Rights Law Centre did that in the Barwon case, where we had the Victorian government sending children as young as 15 to a unit in an adult prison, Victoria's most notorious adult prison, maximum security adult jail down near Geelong, into conditions that were appalling. Extended solitary confinement, use of handcuffs, very limited time outdoors, if at all in the early days, denial of education and so on, use of force, risks to the safety of the kids, unlawful use of capsicum spray, etc. And we used the Charter to challenge that, and we said in a number of cases, and ultimately the court said there is an ongoing human rights issue here, and we are going to issue an order to stop that ongoing human rights breach, and that was what ended the detention of those kids in those awful conditions.
Okay, we have a question in the middle.
Hi, Duncan Storer from Victorian Kids in Care Advocacy Service. The Victorian Charter is basically what stopped the homeless ban in Melbourne. I'm just very curious as to what's wrong with our charter that we can treat children the way we do in youth justice and out-of-home care, when the same charter was successful at stopping the homeless ban.
So one of the things I'll give a plug for tonight is we've been working on these guides to Victoria's Charter, because we think the Charter's underused and we think there's much more potential to use it than it's been used so far. And we have been looking at the way human rights laws like the Charter have been used in other jurisdictions overseas. And on our website, and there's some copies out the front, we have some issue-specific guides for disability, homelessness, protest rights, prisons, etc., homelessness, to explain how the Charter has helped people and how the Charter could help people in the future. So we want community groups, advocates, lawyers to be raising the Charter in their advocacy with government. Most of these issues get resolved well away from any courtroom. They get resolved because if you have enforceable rights protection, governments take them seriously, and when you raise a human rights breach, most times government will say, okay, we'll fix it. But sometimes you have to make sure that you can enforce it in court when government disagrees with you. And that's what happened in that Barwon case, and has happened in other cases around evictions and appointments of administrators to people with cognitive disabilities, etc. So have a look at those guides. I'm happy to talk outside about any specific issues.
John Glover, RMIT. I'm concerned, Hugh Kretser, and I wonder if you share my concern, that the Human Rights Charter is perceived as adding to human rights and creating new law, in that it's used in civil litigation to bolster otherwise impossible cases. I'm just wondering, is this an inevitable consequence of the Charter of Human Rights?
I'm in favour of a charter being used to compel governments to comply with human rights. The experience from the UK, so there's been big case audits done of the UK and in Victoria as well. The Law Institute of Victoria has a charter case law database, and it's looking at what impact has the Charter had on legal actions in Victoria. And yeah, there were naysayers saying that there was going to be this floodgates of litigation. That hasn't happened at all. In fact, judges have been far too conservative about adopting the Charter. The Parliament clearly said to the courts, here's the Charter, go use it, interpret laws consistently with human rights. That is a meaningful tool at your disposal. Apply and use these remedies to fix human rights issues, and courts by and large have been very slow to take that up. But again, it's in the government area of lawmaking and policy that the Charter has had its greatest impact. And I'll give you one example by that. We were approached by some public housing residents, and there had been a number of public housing protests on housing estates about the government's public housing policy. And the government responded to that with a new policy that said, you cannot hold political rallies on public housing estates. Politicians can't door knock on public housing estates, which is a boon for some people, but also a restriction of a democratic process. You can't book community facilities or put political notices up on notice boards. This was a clear breach of rights to participate in public life and freedom of assembly under the Charter. And we saw this policy and went, what's gone on here? Spoke to the public housing residents, wrote to the Office of Housing and the policy. We said, why have you done this? And they said, oh, it's because we can't have a rally at 10 o'clock at night when people are sleeping and it'll disturb. And we've gone, fine, have some rules where you have a permit system where you say you can hold a rally in these times of the day. But don't ban it outright. And that's what a human rights charter does. It says, what are you attempting? Here, I think they were just trying to ban protest that was uncomfortable for them in an overreactive way, and normally you would never see any of that in public. For some reason, this particular policy had not gone through the right channels. They hadn't actually done their charter analysis. They published it, we were involved, and we got it fixed. But normally that happens quietly within government. You talk to people who are drafting legislation, they go, the Charter has had a big impact in the way we actually draft legislation, in the way policies go up, in the way cabinets actually discuss issues of social policy. The Charter's promoting transparency. It's forcing people to think about human rights and where rights are actually engaged and limited, to limit the impact on rights in a way that review of the UK Human Rights Act said much better targeted human-focused policies for the better of society. Does that answer your question? Between citizens. Yeah, so the question was, how does the Charter affect civil litigation between citizens? So charters and human rights obligations typically attach to governments in their relationships with citizens, but those obligations require governments to create systems of law and policies that actually regulate the relationships between citizens and corporations. And so most of the civil litigation around the Charter in Victoria is between citizens and governments, but for example, where private corporations are delivering government services as a private prison or some outsourced provider, community housing providers, for example, the Charter can be used to compel action in those circumstances.
I'll come to that question in a minute, but I have a follow-up to John's one, which is exploring a bit further the potential use, or is it intended that a federal charter would be able to be used to challenge actions by private corporations, for example? So I know, for example, in Canada, that the charter, unions have tried to use the charter to challenge employers who deny the right to collective bargaining or the right to strike. So could what you're talking about, is it envisaged that it would be able to be used to challenge the actions of private actors like businesses?
Yep. So the model proposed by the Brennan inquiry didn't recommend that corporations themselves have human rights obligations. Rather, it put those obligations, said those obligations should be on government, but again, in government, setting up those systems that protect human rights, they're systems of law and policies that regulate human rights. When under a charter, courts are required to explicitly interpret human rights laws compatibly with human rights. So if you're looking at the interpretation of a law around the right to strike or freedom of association, courts under a charter will be actively interpreting that law as it regulates the relationship between employees and an employer, or a trade union and employer, in a way that is compatible with rights protections.
Okay.
And of course, there's the UN guidelines on business and human rights that we're relying on in our advocacy around issues like the involvement of private corporations who are running offshore detention camps, which led to a number of corporations exiting from those arrangements.
Okay, there was a hand up at the front here. Got the microphone?
Hi, Rajesh Sharma. My question is that from your study, have you found out that why some states are so active to adopt the charter, others are not? Is it the political reason, or is the society is not developed enough, like not curious enough to do that? Or they are still struggling with the concept of like human rights or right to be human? Which one should come first?
Can I just clarify the question? Were you asking why is it that some states have got charters and others haven't?
Not. Yeah.
Yeah. Rob Hulls was in Victoria. No, I mean, it takes community support and leadership. Why do we have Queensland on the verge of getting a charter? And it is seriously partly as a result of the extraordinary way the Newman government behaved. Laws that looked like they were invented by a Year 11 high school legal studies student about how to get tough on crime, which included things like forcing prisoners to, policies to force prisoners to wear pink jumpsuits as if that was a bad thing, like ridiculous laws. And that government got voted out. So you see democracy in action, saying we're actually really uncomfortable with this overreach by government. So that gives me confidence in the electoral process as a check and balance, but it also said we need to make sure there are better safeguards in the lawmaking process in the way that government interacts with citizens, and that's why we're on the verge, why we have a government, the Pal Street government in Queensland, close to achieving a charter. They're introducing a charter at least to the Parliament, which should go through. But it's not going to happen by itself. We need community support. We need the people, the groups, the affected communities. We don't need lawyers talking about this, to be honest. We need people who are experiencing homelessness, the organisations that work with them, people who are interacting with the NDIS, people who are interacting with unfair social security laws, There's examples like the health records legislation, the remote community work for the dole. It's people who are affected by those kinds of laws and policies that we need to support to be champions for a charter, because it's them who will benefit the most from the charter, and it's their voices who will be the most compelling to the community, not the voices of the lawyers. And that's what we're working on in the campaign. So you'll be hearing less from lawyers and more from affected people about why a charter is so important to Australia.
Do organisations in Australia that defend or protect rights currently have the means or tools or processes to start building a collective log of claims documenting when rights have been denied or violated by government? And how could that sort of claim be pursued collectively through international means or processes?
So the question is, do organisations that work on human rights issues in Australia have a way of collating a log of claims or a list of human rights abuses and a way of progressing those? Probably a good answer to that is to say what we do have under international law, we don't have courts and an international police that can say to Australia, stop breaching the rights of refugees or we're going to force you to do that. So there's human rights protections aren't generally enforceable at international law, but there are mechanisms that put pressure on governments internationally to comply with human rights and that actually assess nations' rights records against the commitments that they have promised to uphold. And so every 4 years or so, there is what's called in UN language the Universal Periodic Review, UPR for short, a very dull name for an important mechanism, which is basically a peer review of Australia's human rights records. And so us and other non-government organisations will pull together a catalogue of issues where there has been progress. We want to celebrate the progress. We want to encourage governments to take action to do good things. The Turnbull government, as I said, signed the optional protocol to the Convention Against Torture. That will establish a mechanism that will see independent inspectors going into all places of detention to prevent torture and mistreatment. It will make the horrors of Dondale less likely. It will make abuse in immigration detention centres, in Australia at least, less likely. And we want to celebrate and recognise those advances, but we also highlight where the problems are, and we work to get international pressure and recognition of those problems, and then we hold Australia accountable to that, but we can't do that in an enforceable way, so it's done through those pressure and advocacy mechanisms.
Okay, and we'll make this the last question. Thank you.
Thank you, Virginia Rigoni. Thank you for your presentation this evening. My question, you partly answered that, but in just the last response that you gave, but my question was about, apart from signing the petition for the Federal Charter of Rights, what have we seen the international community do with respect to applying a bit of pressure, and what might we see with the upcoming trade agreements, for example? And is there a chance that there can be some pressure applied, for example, as the EU is doing with respect to the Paris Agreement, and they have said that they're going to include, they want to see that the Paris Agreement is agreed to and upheld before they start to secure trade agreements. So is there something that we could expect from the international community that we haven't seen before? Thank you.
The mechanisms of international law are imperfect, and I talk to colleagues who work in international trade law, where there are actually ways of enforcing international law because they can access assets. So if there's a dispute between the US and Venezuela, and there's Venezuelan national airline aircraft in the US, they can seize those aircraft and say, comply with these obligations or we won't give you your planes back. So there are some stronger mechanisms under international trade law to actually get enforcement around international law. It's harder in international human rights law, and very sadly what we see is the politics of convenience in Australia, where we're very happy to criticise countries where there's no political loss for us, and that's like North Korea or Syria. Australia has been great on the Security Council in those two issues, but where it comes to criticising the collapse of the rule of law in Nauru, or it comes to criticising corruption in PNG, or war crimes in Sri Lanka, when we're trying to keep the Sri Lankan Rajapaksa regime on side, that's where we see Australia being far too cowardly around standing up for the international human rights system. And Australia's a member of the UN Human Rights Council now, and it's doing some good things on that council, particularly for LGBTI rights, where Australia is a real leader. Again, when it comes to criticising the government in Myanmar for ethnic cleansing, Australia really stood out as weak in contrast to the statements of the US and the UK. And that international pressure, it's very hard to predict the causation, but it does have an impact, and it is important. And sadly, with the US retreating from that system, the need for Australia to play that leadership role is even more important.
All right. Well, we might bring proceedings to a close. I've got a few things to say in doing so. Again, thank you, Hugh, for such a wonderful and thought-provoking lecture. I think we might recognise that with some applause right now. A former Victorian Attorney General ventured the view in 2012 that you weren't sufficiently qualified to be appointed as this state's Equal Opportunity Commissioner. No, it wasn't Rob Hulls. But clearly it's a testament to your status in the legal and human rights world that you've drawn one of the largest turnouts to our Higinbotham Lectures, so we thank you again. I do have a couple of gifts for you. They're both in here. One of them is an existing biography of George Higinbotham, and it's very pleasing to hear there's another one on the way. We look forward to that. Secondly, something that you'll possibly welcome even more, I had a tip that you're a keen camper and bushwalker, so there's something in there that will help you with that as well. So that's our way of saying thank you again. Look, in closing, I do want to thank the College of Business at RMIT events team, Lauren Gothals, Patricia Vo and Amy Harrington, for your professionalism in making tonight such a success. And to the professional staff of our school, the Graduate School of Business and Law, Linda Batrich, Stephanie Bryceland, Greta Giovinazzo and Amelia Moody, who all provided assistance leading up to and on the night tonight. There are others here who I don't actually know, but who are taking photos, helping with sound and video, so thank you also to you. And quickly, a plug for a new book by our RMIT law colleague, Dr. Adam Fletcher, who's sitting in the front row over there and doing some live tweeting from the lecture. So Adam's got a new book out, Australia's Human Rights Scrutiny Regime, Democratic Masterstroke or Mere Window Dressing, and further details about the book are available from Adam outside, along with information about the Human Rights Law Centre and Amnesty International. So thank you again for attending, and please feel free to join us in the foyer for drinks and refreshments. Thank you.